This video is entitled High-Tech Bootcamp, and it is designed not just for high-tech companies seeking to protect their products and market, but anyone who's created an IP-related invention. This is Charles Mosser speaking, and I've been an IP attorney for over 25 years and also the founder of the Mastercraft law firm, which has 8 offices in Texas. I'm also the founder of a software development company called SpeakSoft, which is attempting to create the first program which can pass the Turing test. In my spare time, I enjoy creating computer programs in the Python language. As I do in all of these bootcamp presentations, I will distill the critical 3 points down to 3 angles of a triangle, which I call top tips for high-tech companies. The apex of the triangle is IP legal protection, followed by contract safeguards, and finally, market considerations. Let's start with IP legal protection, which is the most critical element to understand. Do not even whisper information about your invention without visiting with an IP lawyer, as it could be stolen before you finish your sentence. Mastercraft has multiple cases which deal just with this issue, and it's heartbreaking to have your idea stolen, but it happens all the time. Once your idea, whether it is a mechanical device or computer-related concept, such as a program, is sufficiently developed or rendered, it makes sense to get what is known as a patent pending or provisional patent filed. This is way less expensive than a vetted utility patent and is designed to protect your patent concept for 1 year pending the file of a more complex patent application. Although it is a placeholder, it will protect your IP computer program or device or product while it is perfected and funding is obtained. More on that point in a moment. The good news is that it is easy to prepare and it is not examined at all by the patent office. The not so good news is that protection only lasts for a year. And if you fail to convert the provisional patent to a utility in 365 days, you lose your protection. The other form of IP protection is copyright, which applies to most apps which rely on computer code. This is easy to protect, and new rules as to the Copyright Office Trade Secret Department allow for protection of trade secrets through redactions on the file code to prevent reverse engineering. What this means is that the code is printed out as actual pages and physically redacted via computer to prevent reverse engineering by anyone examining the code. And it works. I could tell you that based on my personal experience as a programmer. Finally, your IP invention will be protected in Texas and most states under a statute known as the Uniform Trade Secrets Act, which prohibits third parties from stealing trade secrets, which definitely includes computer code. In Texas, it's called TUTSA, or the Texas Uniform Trade Secrets Act. However, enforcement under this law is not seamless and more expensive to secure than filing a patent or copyright, which should not be omitted. It is just extra protection for the more sophisticated client, as it allows for easier injunctive relief and nailing the bad guys. Contract safeguards are the second point on the triangle and critical for IP protection. Anyone who touches, and I mean touches or looks at your code or device, should sign a contract which not only contains the standard NDA non-disclosure language, but imposes severe, and I mean severe, penalties for violation, which could include taking your IP jewels to a competitor or doing it themselves, which often happens. Recommended provisions include injunctive relief, where they acknowledge that there is a legal basis for granting an injunction and will not oppose it. This relatively simple term and their agreement to it will save you tens of thousands of dollars, but critically protect your IP. You can also add a liquidated damage clause, which makes the offenders pay big time in cash for bad acts. Now, if a contractor or employee gives you a hard time about these provisions, send them packing immediately, because they are no good nicks. If they didn't have bad intent, they would sign the dotted line in an instance. The same regime contractually should apply to your beta testers, even if they are good friends, even family members. Anyone who touches or looks at your IP or code has to sign an agreement. Make no exceptions. The third and final point in this broadcast is market considerations, which is critical to IP protection. This is often overlooked. If you are relying on a third party to manufacture or distribute your product, you must have proper contract restrictions to protect your product, whether an actual device or software. Please refer to the second triangular point for tips, but anyone in the supply chain needs to execute an NDA with teeth. If you have a software product, you want to protect against anyone ever seeing the source code. Keep controls in place to prevent access and only allow download to the operational system, not the code itself. Even if you have contractual safeguards in place, never let anyone except key personnel touch the source code and make sure they sign the agreements above. Market considerations also relate to funding issues. When you first start your company, choose a simple entity which can be expanded to bring in investment capital, such as an LLC. This structure can be utilized to bring in what are popularly known as silent investors. Now, sometimes a more complicated corporate structure is required if you want to actually issue stock that has market value. Discuss that with a corporate attorney. Never do that on your own. This structure can be utilized to bring in what is popularly known as silent investors. That said, consult again a corporate attorney, as you can easily violate state and federal securities laws if you are not careful or properly advised. Critically, avoid investors who demand control of voting or ownership, as your entrepreneurial experience can easily turn into your worst nightmare. And that's our broadcast on High Tech Bootcamp. At the Monstercraft Law Firm, we have 8 offices to help you achieve IP success. This is Charles Monster speaking, wishing you prosperity in all things. Thanks for joining us.